So welcome to this afternoon's session on reconstructing, no, we're not on that, we are on the role of international law in achieving climate justice. And we have four fantastic panelists who are going to be covering very different aspects of law and climate change. Not really perspectives, but actually aspects. So first of all, we are going to have Ms. Crisela Bernardino, who's a researcher in corporate climate change litigation. And she is going to talk to us specifically in relation to the Philippine case against the fossil fuel majors. And then we are going to have Mr. Selman Aksünger, who's a PhD candidate at Maastricht University. And he's going to talk to us about the concept of permanent sovereignty over maritime areas despite sea level changes. His paper, which I've read, very interesting. All of them are. We are then going to have Ms. Jessica Crow, who's a PhD candidate in Cambridge, talking about emissions trading and investment treaties. One of the problems that besets attempts to deal with climate change, ironically, are investment treaties. And she raises some very interesting and difficult questions. And finally, we're going to have Ms. Katharina Neumann, who's a DPhil candidate in Oxford, who's going to talk about the agricultural sector, specifically the fact that, of course, the Paris Agreement doesn't distinguish between different sectors, but that doesn't mean that the duty of due diligence, which we heard about in the keynote speech, doesn't cover agriculture as one of the main causes of GHG emissions. So each speaker will speak for about 15 minutes, and then we'll have some time for questions at the end. So keep a note of your questions as we go along. Thank you.
The irony is not lost on me that as an advocate for giving voice to the voiceless, I barely have any voice today. But if I have to cough through this presentation, I'll do it. It's not every day that I get the chance to talk about my home country in an international forum like this. Judge Hyder gave me a perfect stage to ask the first question. What does colonialism have to do with climate change? Imagine a coastal village in the Philippines battered by the most catastrophic typhoon in the nation's recent history. Homes were washed away, lives were upended. Now consider that a century ago, colonial authorities razed the mangrove forest and exploited the land for profit. This is what happened during the Spanish and American colonial era in the Philippines for more than 300 years. This colonial plunder not only generated profits for the colonizers, it also stripped local communities of natural defenses. When the colonizers left, they left behind a fragile landscape, hillside prone to landslides, and coastlines without protective mangroves. Fast forward to today, deadly typhoons hit those same Filipino communities much harder because the ecosystem that should cushion the blow was weakened by colonial-era exploitation. The question now is it an accident of history that those who contributed the least to climate change suffer its worst impacts? Or is it part of a larger story of injustice? With this question, typhoon survivors and NGOs in the Philippines petitioned the Philippine Commission on Human Rights to investigate 47 of the world's biggest fossil fuel and cement companies for climate-related human rights violations. This was the world's first national inquiry on climate change, a fact-finding investigation similar to a Truth and Reconciliation Commission. The petition made an explicit connection between colonialism and climate change by tracing greenhouse gas emissions since 1751, attributing much of the pollution to the world's largest carbon producers since 1751. By starting the clock in the mid-18th century, the petition underscored that the Industrial Revolution, powered by colonial extraction of resources, marked the beginning of humanity's massive carbon emissions. And one of the most powerful voices in the national inquiry were the indigenous communities, like the Igorot, Lumad, Dumagat communities. They emphasize how ancestral lands, sustainably managed for several generations, were fragmented by colonial exploitation, weakening their resilience today. For example, Dumagat communities in the Sierra Madre Mountains were displaced from fertile lowlands into uplands, and their forest management practices were demonized as slash and burn by authorities. The colonial imposition of state forestry, reserving timber for commercial use, criminalized the indigenous practices. The result in the long run, forests were overlogged, and indigenous stewardship was weakened. Now, with climate change bringing heavier rains, those denuded or monoculture plantations in the Sierra Madre Mountains are more prone to landslides and flash floods, endangering both indigenous and downstream communities. Now, throughout the proceedings, Filipinos articulated a narrative of climate justice that demands recognition of this history. Indigenous leaders argued that restoring their land rights is not just about justice, it's an essential practical step to climate resilience. And the Philippine story is not an isolated case. It is mirrored worldwide. Communities from the Amazon to the Himalayas, from sub-Saharan Africa to South Pacific, they all share stories remarkably similar to those heard in the Philippine National Inquiry. In Latin America, global demand for lithium, cobalt, and rare earth metals needed for electric car batteries and renewable energy has led to mining boom on indigenous lands in Bolivia, Chile, and elsewhere. This has been termed as green colonialism, policies ostensibly aimed at sustainable development, but end up displacing local communities and degrading ecosystems, much like the colonial mining and plantation enterprises under Spanish and Portuguese colonial rule. Latin American activists are now invoking the concept of climate debt to demand reparations from former colonizers. Now, in Africa, continued exploitation like oil extraction in Nigeria, initially established under the British rule, continued to extract profits while causing oil spills, pollution, climate heating emissions, and economic vulnerability, essentially creating a form of climate apartheid. This drives demands for recognizing ecocide to enforce accountability on global north polluters. Now, all these experiences fuel a global South call for decolonial climate justice that demands not only emissions reductions, but also historical accountability. And what does international law say about this linkage between colonial history and climate injustice? Well, I say not enough. One fundamental problem is that colonialism, for all its devastation, wasn't illegal under the law of its time. The empires wrote the rules, and the rules facilitated imperial exploitation. Consider the doctrine of terra nullius, which treated indigenous lands as empty and available for the taking. That leaves a legal blind spot. Colonial harms are widely condemned morally, but they are not classified as international wrongs that generate clear legal liability. And what about human rights law? Over the past few decades, human rights treaties have become a key tool for climate litigation, focusing on rights to life, health, culture, and so on. However, critics argue that the human rights framework is largely ahistorical and individualistic. It views harm in terms of immediate violations to individuals or groups, rather than chains of causation stretching back generations. Because of this, human rights litigation has not provided reparative justice for colonial-rooted climate harms. Moreover, there is pushback against applying the traditional doctrine of state responsibility, which requires direct link between a state's action and the resulting injury. This becomes problematic in addressing climate change, where no single storm or wildfire can be directly traced or attributed to the actions of one state alone. Also, corporate actors whose carbon footprints sometimes are even larger than those of medium-sized countries often lie beyond the reach of courts. In fact, several carbon majors questioned the Philippine Commission's jurisdiction, arguing that many carbon majors had no physical presence in the Philippines and that climate change falls outside traditional human rights framework. In essence, international law to date has shielded extractive enterprises more than it has constrained them. Given these gaps in international law, where can communities seek justice? Increasingly, the answer has been at home and in regional forums. In recent years, we've seen a surge of climate litigation at the national and regional levels. This brings us back to the Philippine inquiry. The Philippine Commission took into account the testimonies of those severely impacted by climate change and expert witnesses, including Richard Hede's pioneering peer-reviewed study in climate attribution science, which reveals that 90 carbon major entities, including the carbon majors subject of the inquiry, are responsible for 64.8% of all anthropogenic carbon dioxide emissions from 1751 until 2013. The national inquiry concluded, among others, that first, the Commission had jurisdiction over the petition, notwithstanding that some carbon majors did not have physical presence in the Philippines because their actions directly affected the enjoyment of fundamental rights of Filipinos. Second, even those companies that are not directly bound by any climate treaty, they still have a duty of care. They must exercise due diligence and cut emissions under principles of human rights and corporate responsibility. Third, the state has the duty to hold private actors accountable for climate change impacts as part of its duty to protect its citizens from human rights violations. The national inquiry, along with other cases, are part of what we see as a patchwork of judgments and opinions forming across jurisdictions. Bit by bit, they might even be coalescing into broader principles, perhaps even seeds of general principles of international law. Now, while the Philippine inquiry can serve as a blueprint for climate litigation in several aspects, it fell short of delivering comprehensive climate justice. The Philippine Commission labeled major emitters' actions as violative of human rights and even called them immoral, but did not recommend and could not order reparations for colonial harms. This underscores the limits of domestic efforts. For one, inconsistent position can blunt progress at the domestic level. We've seen corporations invoking the ambiguity of obligations under international law as a shield. For example, in Eco Oro versus Colombia, when the government of Colombia halted a gold mine to protect Santurban wetlands, mining company Eco Oro invoked the Canada-Colombia Treaty. In 2021, ICSID found that Colombia unfairly disrupted the investors' legitimate expectations of mining, thus breaching its right to fair treatment, even though ICSID acknowledged the ecological importance of Colombia's action. Therefore, Achieving climate justice requires that international law develop both bottom-up and top-down, with domestic courts and global frameworks reinforcing each other. Currently, national courts are already using principles under international law. The Philippine Commission, for instance, drew heavily from human rights treaties, international environment law, including the Paris Agreement. These domestic decisions, in turn, should be feeding into the evolution of global norms, adding to the moral and legal pressure on the international system until it becomes increasingly untenable to maintain these double standards. The key question now is, can international law, arguably a creation of the Western mind, historically slow to address equity and justice, effectively confront colonial climate harms? This brings us to a telling historical analogy that might suggest a path forward. A powerful example from the International Court of Justice over half a century ago demonstrates that moral reasoning and voices of principle can pave the way for legal reform, even if they are initially ignored. In 1966, in a case concerning Southwest Africa, what is now Namibia, Judge Kotaro Tanaka of Japan issued a famous dissenting opinion. The case was about apartheid and the treatment of people in what was then a territory that was administered by South Africa under a mandate granted by the League of Nations. While the majority sidestepped addressing apartheid's injustice, Justice Tanaka boldly argued that natural law principles, foremost among them, the moral equality of human beings, are part of the very fabric of international law, even if not explicitly written in the treaties. In his view, apartheid was incompatible with this principle of equality. Although his opinion did not prevail at that time, it profoundly influenced global consciousness. Commentators noted that Tanaka's dissent shook the conscience of the court, eventually inspiring legal developments. And when the ICJ explicitly acknowledged, the concept of obligations erga omnes 4 years later in the Barcelona traction case, it showed that Tanaka's dissent was indeed powerful. The concept of obligations erga omnes, as we all know, recognizes that certain severe violations, such as apartheid, slavery, and racial discrimination, harm the entire international community. So why do I bring up Judge Tanaka? Because today's climate justice movement finds itself in a similar position, pushing fundamental principles of equality and humanity to the forefront, even when formal law is ambivalent. I would say that the call for decolonial climate justice now is a form of dissent against the status quo of international law. We can look at tensions between ambitious domestic institutions like the Philippine Commission on Human Rights and slower international systems either as deadlocks, or we see them as catalysts that highlight critical gaps and force us to confront them. As national courts increasingly recognize climate duties, their collective weight pushes international institutions towards acknowledging those duties too. Conversely, international bodies like ICLOS, as we heard in the keynote earlier, can empower and guide further domestic actions, creating a reinforcing cycle. And we're seeing early signs of that synergy now. In essence, domestic climate action is stress testing the international law system, revealing its flaws, but also pointing to how it might be refashioned so that the moral arc bends toward climate justice. Thank you.
All right, good afternoon, everyone. Following the practice of my co-panelists, Judge Aurescu have also made the pay for me to talk about to you today the impacts of sea level rise in international law. My presentation concerns the role of permanent sovereignty over national resource principle with regards to preserving maritime areas. The outline of my thesis is, the outline of my presentation is going to be about talking what are the legal implications of sea level rise. Sea level rise has implications in different aspects of coastal configurations. It has an implication on right to housing, right to property, people. There is a human movement aspect of the sea level rise as well, but specifically I will talk about how to preserve the maritime entitlements in the context of sea level rise. There is a work of a great growing body of literature of this area, and especially the International Law Association has established a committee on sea level rise, which was the main body who worked on this topic. And then the topic has been taken by ILC. Judge Aurescu has already mentioned about that, so I'm gonna really quickly pass that part. And then I'm gonna talk about what is the state response, especially these states who are the key victim of this problem. Small island developing states has produced as a result to this problem fixed maritime zone approach. And then at the end, I will try to briefly explain what I think that could be a good solution to this problem, using permanent sovereignty principle as a normative framework to maintain resource sovereignty. When we talk about this sea level rise problem, the IPCC panel in its 6th assessment report is predicting that at the end of this century, the sea level will increase. The global mean level will be 1.1 meter higher than what we have now. At the outset, it would sound to you like 1 meter is a negligible amount of increase, but it can be very essential for the states who are low-lying, especially the states such as Vanuatu, Kiribati, Marshall Islands, and Maldives. Those of the states has 90%, and some of them are even 95% of their land area just below the 5, just above the 5. The whole area is just above the 5 meters above the sea level. So increase of a 1 meter, 2 meter will probably mean half of their territory will get submerged. So this is something that a pressing issue. For instance, the 7 out of 900 islands of the Solomon Islands has already submerged in the past 5 decades. So this is a currently pressing issue for many of the Pacific Island states. So what we are trying to explain when we say the legal impacts of sea level rise, when the sea level rises, the low water line, which we use in order to measure the maritime entitlements, the territorial sea, the contiguous zone or the exclusive economic zone, are also moving towards the landward direction. When the sea level rises, the low water line goes towards the landward direction, and the outer limits of the territorial sea and exclusive economic zone will also move or shift accordingly. What that means? That means part of territorial sea will become part of contiguous zone, part of the contiguous zone will become part of the exclusive economic zone, and part of the exclusive economic zone will become high sea. So that means a loss of maritime entitlement, especially with regards to the natural resources. In the case of islands, the situation is even worse, because if an island becomes uninhabitable, even before totally submerged, becomes uninhabitable, then the island, according to Article 121 of the UNCLOS, will lose its island status. If it's become a rock, then it is not entitled to have 200 nautical mile zones of exclusive economic zone. So that means a huge loss of maritime area for the small island developing states. If you look at, for instance, this map, imagining that the island A has submerged totally, then the low water line or the archaeopelagic baseline will be drawn between the island B and C, and then the lost area where we see there on the on the west side or northwest side of this map is going to become part of the high seas. And if you look at the map of these Pacific area, although those states are very small in their lands, these are the huge maritime states. And losing these exclusive economic zone means that those states will lose huge maritime area, which is essential for their economic survival. And this issue has been first addressed by the baseline committee of the International Law Association. International Law Association's baseline committee, which was operative in 2011, early 2010s, they recommended that the ILA should establish a separate committee to address the impacts of sea level rise. And the ILA did so, and the ILA produced 6 reports with regards to the sea level rise and a couple of declarations in order to preserve, but their area of work or their work has concentrated on 3 issues. The issue of the law of the sea, which I have explained a few minutes until now, the issue of human rights and migration issues, and the third, the statehood issues. The topic has then taken by the mandate of the ILA Committee on the Sea Level Rise has just finished in 2024 with their last final Athens report. The ILC study group, which is about to finish also its mandate, has been very well explained by Judge Bogdan Aurescu, so I'm not gonna talk much more about that, but their area of focus is also can be concentrated under 3 topics, which is law of the sea issues, human rights and security, or peace and security in their formulation. And the third issue is also statehood in the ILC. The formulation of migration to peace and security by the ILC is meaning that they are more focused on the resource rivalry aspect of, or the peace and stability aspect of having fixed maritime zone. Now, I'm trying to bring this issue to the state responses. So the key victims of this sea level rise problem, the small island developing states, has come up with an innovative solution. Their interpretation of Article 5 of the UNCLOS, which means that the low water line is the starting point of measuring the maritime entitlements, is or can be fixed. What they argue is that once the baseline has been determined, there is no under UNCLOS to update it. So if a state, one certain point in the time, permanently defines its baselines or permanently defines the outer limits of its maritime zones and submits this to the DPhil, the UN body which is dealing with the submissions of state with regards to their baselines and outer limits, they have no obligation to update it. So imagining that a state has submitted its charts, very detailed charts about the location of their baseline or outer limits, and 50 years later, 100 years later, the low water line has shifted towards the landward direction. So we will have an extended internal waters area or retracted low water line, as you see in this map. So that means there will be a situation where states has a longer or extended exclusive economic zone or territorial sea, which is going fundamentally against the wording of the UNCLOS. So the fixed maritime zone approach has been receiving a lot of criticism for having an extended water area. There is also another way of formulating it. Instead of permanently fixing the baselines, some of the states are defending the positions that let's keep the baselines ambulatory, so it will fluctuate, but we will fix the outer limits of territorial sea and exclusive economic zone, which is pretty much producing the same result and not adequately addressing the critiques coming to this approach. And there is also a growing regional response or regional support to this fixed maritime zone approach. Starting from the 2010, different Pacific organizations, intergovernmental bodies have produced different soft law documents, referring from the first panel, different non-binding declarations and commitments in order to preserve their maritime zone. But the most explicit and most specific of these declarations came in 2021 Pacific Island Forum states, where they say that maintaining maritime zones established in accordance with the convention, which is UNCLOS, and rights and entitlements that flow from them, notwithstanding the climate change-related sea level rise, will be preserved and continuing. So that means those of the states who once upon a time submitted their baselines and outer limits of their maritime zone will not update their maritime, they will not update their baselines or charts, which is a way of permanently freezing their maritime zone. And the explanation for this is that those states are considering themselves as the key victims. They say that we are the countries or states who least contribute to this problem, but paying the highest price of, or paying the most existential price of this problem. And hence, we are considering ourselves that we can use the UNCLOS articles for saying that there is no obligation for states to update their maritime zone. And there is no actually a body in international law which is observing or checking the reality of or accuracy of these charts and the physical low water line. Only United States somehow, if it concerns their national interest, they are checking and sometimes protesting, but there is no overarching body which is controlling this physical reality. So my response or my argument here is that there is a role for permanent sovereignty over national resource principle in order to provide the same effect or result of fixed maritime zone approach by not going, this principle will allow the normative framework, but not goes against the objects and wordings or the articles of the UNCLOS. The permanent sovereignty over national resource principle has emerged in 1950s, and the key declaration, General Assembly Declaration 183, is produced in 1962, but has been also repeated in the subsequent declarations of the General Assembly, which is the instrumental legal principle for newly established states or decolonized states to regain their access to their national resources, which has been used by the colonial powers. So this is a principle that gives both states and people. So if a statehood of an island state is also at stake, this right is also being vested to the people as well. This principle allows them to regain their access to their natural resources in the case of having lost their access to these key natural resources. And the applicability of this principle has also found its way in non-colonial contexts. The human rights treaties, the twin covenants, ICCPR and International Convention for the cultural and social rights, they are also including or incorporating the permanent sovereignty over natural resource principle, the Convention Against Biological Diversity, and many other regional international treaties are also including or incorporating permanent sovereignty principle. And this principle will give the island states to argue that they can maintain their access over those natural resources despite the changes in the maritime zone. Even the maritime zone shifts towards the landward direction, they can still claim the ownership of the national resources that goes beyond or shores of their entitlement. So in this presentation, I was trying to make, or with this permanent sovereignty principle, I'm trying to make three key points here. The permanent sovereignty principle is providing a compelling legal foundation for preserving maritime entitlements despite the geographical change occurring in the coastal states. Secondly, by anchoring zone preservation is a well-established legal principle, and we can achieve both stability and flexibility of maritime zone in responding to the unprecedented challenges coming from the sea level rise. And third, finally, the international law has an existing mechanism and already existing principles which we can reinterpret in order to use these new situations instead of arguing that the UNCLOS is incapable of addressing this problem or we need a new treaty for preserving the maritime zone, etc. I think we have enough rules or applicable rules within the dockets of international law to apply this new situation. Thank you very much for your patience and attention.
I don't have any slides, so we're gonna stay with this for the new topic. So I'm happy to be here today to be able to present on a Canadian contribution to international law on a particularly momentous day for Canada. I'm not going to be talking about that election, though. I'm going to be talking about a different election, an election in 2018 when the Conservative Party of Ontario campaigned on a promise to axe the tax and cancel the Ontario emissions trading system and its link to the Western Regional Cap and Trade Market, which linked Ontario's emissions trading system to Ontario and Quebec's. And when it did that, when it was elected and it did just that, it didn't just strand carbon credits, it inadvertently created the first test case of whether emissions allowances are protected investments under international investment law. And I'm talking, of course, about the case of Koch Industries versus Canada, which is one of the last NAFTA cases under its legacy provision. And this case represents the tip of a much bigger iceberg. The proliferation of cross-border emissions trading raises important questions about the compatibility of international investment law and climate governance. And by examining the possible treatment of carbon credits as protected investments, my presentation is going to try to illuminate a new specter of tension between climate policy objectives and international investment law. And this is an intersection that creates new legal risks for states as they try to implement market-based climate policy. And although these tensions have been explored and noted extensively when it comes to fossil fuel regulation and the ECT, they've yet to really be explored in the context of market-based price and carbon market mechanisms. And this context is actually evolving rapidly, and this is due to the central role of carbon markets in international climate negotiations. Carbon markets have become the preferred regulatory tool for states to meet their commitments under the Paris Agreement, and it's understandable why. It's a much more politically expedient regulatory tool. It's a lot easier than implementing a fossil fuel phase out, than stranding massive energy infrastructure. It can be implemented more readily, and you throw the problem to the market. And so it can be quite a politically expedient politically expedient tool. And for this reason, we've seen a lot of focus on the development of rules for a global carbon market under Article 6 of the Paris Agreement during the COP negotiations. But what's interesting, and of course, this is not going to be, this will be familiar to everyone in the room, is that these policy tools exist within a really complex web and framework of international legal agreements, including international investment agreements. And as we see domestic carbon markets start to mature, there's a growing trend to linking these markets through bilateral and multilateral instruments. And if we think about it and we just kind of take a carbon market in isolation, it really is an archetypal dynamic policy tool. It's subject to market forces and environmental policy objectives, and it's exactly the type of an unstable measure that can give rise to investment claims. And so this presentation is going to go through how and look at how the combination of domestic property law and the specific implementing instrument may determine the investment protection status for an emissions allowances. And a key insight is that variations in either of these types of instruments can create an entirely uneven protection landscape across linked markets that intersect with investment protection regimes. And this is implications both for investment protection and conversely for states' regulatory flexibility when it comes to implementing market mechanisms. And to explore the implications and their significance for global carbon markets, I'll first provide a little bit of a background on the evolution of emissions trading systems and the legal status of carbon credits. We'll look at the Koch Industries and Canada case and examine some comparative approaches to the property status of emissions allowances across jurisdictions, looking specifically at a contrasting case by the UK High Court, which took an entirely different approach. And then I'm going to conclude with some policy implications for states that are contemplating enlarged carbon markets and reflect on the broader significance of these issues for climate governance. But just taking a step back, What is a cap and trade system? A cap and trade system is a policy tool that caps emissions and allocates allowances to clearly defined sectors in the economy in a given jurisdiction. And at the end of the trading period, each entity must have enough carbon allowances in order to cover its emissions. Those that emit more can buy allowances on the market. Those that emit less can sell their emissions on the market. And the idea is that the ever decreasing emissions cap is going to force, in theory, and incentivize investment in R&D and abatement technology as it becomes more and more expensive to emit carbon. And in addition to this, markets can be designed to include pure market participants who invest for financial gain, and this can drive up the market price for carbon and make it more aligned with the social cost of emitting, for example, or just to create more leverage and stability. So emissions trading systems have evolved significantly since their inception. And I'm talking even way past Kyoto, back to when they were first used in acid rain trading schemes in the 90s in the US. And what's interesting is that they've always been marked by a legal ambiguity regarding their proprietary status. But this ambiguity is not accidental. It's actually reflects a deliberate policy design choice. And so the reason why you often see a carbon credit within a cap and trade scheme called an allowance, it's a deliberate choice which is designed to reflect the governmental nature of the allocation and to try and explicitly exclude the idea that a property right is being created, but without doing it explicitly. So this intentional avoidance of property terminology has a specific purpose, and this is to try and prevent claims against the government that any change or contraction of the market, which is a natural design feature of a carbon market, in the trade system would constitute a regulatory taking in the domestic scheme, or what is also known as expropriation. But this language has been analyzed across all of these different trading schemes into today. And a lot of legal scholars have said that this nonetheless has created de facto property rights, instruments that function as property in private transactions, but are, attempting to deny property status vis-a-vis the government. But what we're seeing, interestingly now, is that this ambiguity at the domestic level is starting to cause problems in international law, because similarly ambiguous language is being used to implement links between markets without addressing the underlying property status question. And likely the market designers who are negotiating the global carbon market under Article 6 of the Paris Agreement are using these precedents when they are developing the contours of the global carbon market. But this, tension reflects basically two competing imperatives, right? On the one hand, the market designers want to try and shield governments from potential claims in order to preserve policy flexibility in a really dynamic space like climate. And on the other hand, they need to create sufficiently secure private rights in order to enable a market to function and in order to allow for secure trading. And this tension manifests in two critical issues as carbon markets start to cross borders. First, it creates uncertainty in private law. While emissions allowances need to have sufficient property characteristics to be tradable, like this ambiguous proprietary status creates a legal limbo that leaves market participants completely in the dark until a dispute arises and needs to be addressed by a court or a tribunal. Secondly, as they start to cross into international investment law regimes, we see investment law tribunals being directed back to the domestic law property characterization depending on the investment law instrument. And as the Koch case demonstrates, tribunals will examine whether they've been defined as property under the domestic law regime and will weigh this against any limitations in the implementing legislation or treaty. And these kind of really converge into what I call the scaling problem. So the current challenges that we're seeing in regional markets and in the EU, where we're seeing member states are resolving these questions all differently in accordance with their domestic law because of the subsidiarity principle. This is going to be exponentially magnified under an Article 6 global carbon market because investment tribunals across multiple jurisdictions will be forced to reconcile vastly different property regimes without any harmonized guidance. And that's not even taking into account any issues of conflicts of law, which may be brought up if you have a carbon market that's operating across different jurisdictions. And the stakes of scaling this problem are particularly high for climate policy as these carbon markets expand globally, and each determination that credits constitute a protected investment could incrementally restrict states' regulatory flexibility precisely when climate science and the reports of the ICC are demanding more aggressive climate policy responses. And so what began as scattered domestic legal ambiguities could evolve into a global constraint on climate action with increasing financial liability for policy changes that reduce credit values. So if we just look at the Koch case really quickly, it was the theoretical tensions, I think, between these kind of property rights, market functionality, regulatory flexibility were tested for the first time in this case. And really interestingly, it really all revolved around this question of whether emissions allowances qualify as a protected investment under the NAFTA. And they looked specifically at the definition of the notion of property. And the facts of Koch are really straightforward. Koch was a US investor. They were a market participant. They purchased $30 million worth of carbon credits in the Ontario carbon market. About a month before Ontario delinked the cap and trade program. Following the political change, Ontario canceled the program. They delinked the system. They stranded the carbon credits, and they said there would be no compensation for market participants. Koch claimed that this constituted expropriation and a violation of the FET standard. Canada objected and said, sorry, no, there's no jurisdiction here on the ground that emissions allowances are not protected investments because they are not recognized as property in Canada. And I think that the tribunal's methodological approach is really instructive in understanding the way that tribunals may approach this in the future. Finding no express definition of property in the NAFTA or in international law, the tribunal turned to the law of the host state, and both of the parties agreed that the appropriate investigation should proceed under the law of Canada and the Ontario courts. But unfortunately, the Ontario courts and none of the courts of any of the other jurisdictions in Canada had expressly dealt with the question of whether carbon credits are property. So effectively, what the Koch court had to do was they had to try and put themselves into the shoes of a Canadian court trying to determine what they would do if they were faced with a novel claim for property of an intangible asset. And so they went into an assessment of what the court had done in analogous circumstances, and they identified the attribute of exclusive control as essential to finding common law property in Ontario. It also had a look at the Cap and Trade Act, which granted government discretion over the rights, very similar language that we've seen in other cap and trade schemes. But this element of exclusive control was really what the case turned on. And so finding that the emissions allowances didn't meet the Canadian law standard for novel claims over intangible assets, the tribunal dismissed the case for want of jurisdiction. But what I think makes this case really interesting is that the Koch tribunal explicitly distinguished approaches to property across jurisdictions, and it engaged with some persuasive authority. Canada being a common law jurisdiction, it often has, it often will take persuasive authority, particularly from the English courts. And it looked at a case where the English courts dealt with this question of whether EU ETS credits are intangible property, and they actually found that they are. And so the English High Court applied a completely different three-part test. It looked to determine whether there was a statutory framework conferring entitlement, whether the allowances were transferable under that framework, and whether the allowances had value. Now, the Koch credits would have met that test, and the Koch parties argued, very, very forcefully that this persuasive authority should be applied to the test. So this different analytical approach shows that had the Ontario allowances been subject to the English court, or if they had found that there was more persuasive authority in the English High Court's judgment, the case may have proceeded to the merits. How am I on time? 5, okay, great. So that's the domestic property law problem. You also need to consider the implications of the interactions beyond the specific NAFTA context. So the tribunal's approach of deferring to the domestic property law characterization would not necessarily be replicated by a tribunal that was constituted under a different treaty, or under, a treaty requiring a double barrel assessment or an assessment under principles of customary international law. There are arguments about the characterization of emissions credits under domestic law might have some weight, but they might not be determinative. So this creates a complex matrix of protection where identical carbon credits could receive different investment protection treatment depending on the jurisdiction of origin and the applicable treaty. So we see the creation of a lottery, which is and a lottery of unpredictability for cross-border carbon trading, and revealing how the intersection of domestic property regimes and investment protection can create uneven terrain for market participation. And it also threatens to fragment the investment protection landscape precisely at the moment that the international community is trying to come together in order to harmonize carbon markets and it's creating uneven risk profiles that can influence capital flows, and it can also potentially distort market efficiency. So it can, have a lot of, negative effects. And I think more troubling is that this variability really only comes to the fore when a dispute arises. It's really an invisible problem. And this introduces an element of legal uncertainty that governments rarely factor in when designing treaties and legislation to implement a link that could in turn give rise to liability for regulatory changes to their carbon markets. So I'm just going to wrap up by saying that I think what makes this topic so interesting is that it reveals some of the deeper tensions in our approach to climate governance. For decades, the literature has grappled with ethical questions surrounding rights to pollute, and emissions trading systems were deliberately designed in order to try and, sidestep this with some legal ambiguities, so that they wouldn't have to deal with some of these uncomfortable philosophical questions. But I think the Koch case really brings these theoretical tensions that have been around since acid rain training into sharp relief, and tells us that the opportunity to carefully define these property rights and create legal certainty in these markets is now, while the Article 6 global markets are being developed. So I will conclude with that. Thank you very much.
Hi, everyone. Today I'm going to present to you a little bit a paper that's part of my overall PhD project, which is on agricultural emissions under international environmental law. Today I want to focus on the climate change regime specifically, though, and how agricultural emissions are regulated under that regime. I've structured my presentation the following way. So first, I want to give you a little bit of context of agriculture and climate change generally, especially kind of looking at the tensions between the scientific necessity to reduce these emissions and international actions that are currently taken to reduce emissions from the agricultural sector. Second, I'm going to look at the obligations to reduce agriculture under the international climate change regime. And then third, I'm going to look at a little bit at the practical relevance of such obligations. But starting with the context. So generally, agriculture emissions are defined as carbon dioxide, methane, and nitrous oxide emissions from terrestrial agricultural sources. That's the definition that the IPCC uses for these kind of emissions. The sector alone accounts for up to 13% of global emissions. And if we take the whole food system into account, it actually accounts for up to 37% of global greenhouse gas emissions. So that's quite a big share. At the same time, the IPCC emission reduction pathways say that reducing agriculture emission is essential in reaching the Paris Agreement's objective of reducing global warming to 1.5 degree. So that's kind of the scientific basis regarding agriculture and climate change. But if we then look at international reduction commitments currently, only about 26% of NDCs, so NDCs are the nationally determined contributions that states have to submit under the Paris Agreement, so the national climate change goals. So only 26% of NDCs have quantified emission reduction targets for agriculture, compared to 45% of such NDCs have them for the energy sector. And a lot of actions under those NDCs in the agricultural sector are actually like non-measurable and conditional voluntary. So I think this graph shows this relatively well. So while we see that about 95% of NDCs mention agricultural emissions and the need to reduce them, only about 80% then have specific mitigation actions, and only 40% have specific targets. And then not all of these targets are even quantifiable, and a lot of these measures that are mentioned in NDCs are voluntary and conditional on specific things. So it kind of results in very little action that is that are robust, that states have to take under these NDCs. So this has kind of led to the fact that since the 1990s, agriculture's share of global emissions has grown, mostly because emission reduction in the sector is inherently slower than in other sectors. And there's some justifications for that. I don't want to go into these today. What I do want to look at, though, is whether and to what extent does the international climate change regime, so the primary mechanism for addressing emissions under international law, impose obligations to reduce agricultural emissions. And to answer these questions, we first must go to, must look at the climate change regime, and we first must go to the treaty texts themselves. And when we look at the treaties, it is revealed that mitigation obligations under the Paris Agreement, under the Framework Convention, do not operate on a sectoral basis. So that means that treaties do not contain specific state obligations to reduce agriculture. Agriculture is rather covered under all of the general mitigation obligations under the regime. These general obligations are mostly obligations of conduct and procedural obligations. So procedural obligations are just reporting obligations under both treaties mostly. Where it gets interesting is what is the obligations of conduct. So we've heard a little bit in the keynote speech about the obligations of conduct as well. Specifically, there are obligations where states don't have to pursue a specific result, they just have to put in specific measures. A good example is, for example, Article 4.2 of the Framework Convention, which you can see here, the first paragraph, which says that states should take policies and measures on greenhouse gas mitigation with the aim of returning individually or jointly to their 1919 levels of greenhouse gas emissions. So an aim of returning is kind of the obligation here. The Paris Agreement has similar obligations of conduct. So most famously, Article 4.2, that states should pursue domestic measures with the aim of achieving the objectives set out in their nationally determined contributions. And as we've also seen, also heard in the keynote speech, that these obligations of conduct indicate the relevance of due diligence. So due diligence for these obligations is the standard that states must discharge when they're performing these obligations of conduct. So the argument that I want to make is that the reduction obligations for agriculture can actually be derived from such due diligence obligations under the Paris Agreement. And I'm looking at the Paris Agreement specifically instead of the Paris Agreement and the Framework Convention, because the Paris Agreement has some more specific markers for due diligence. So it's a bit easier to like kind of show what the standard of due diligence under that agreement should be, and it's a bit more specific. So generally, the standard of due diligence or due diligence generally derives from the customary international duty of prevention, which entails obligations for states to prevent significant transboundary harm, environmental harm. So it requires that states adopt appropriate rules, but also that they exercise sufficient vigilance to ensure their efficient operation, as we've already discussed earlier in the keynote speech as well. For conduct obligations, such as those under the Paris Agreement, the due diligence standard sets the standard against which to test whether states have complied with these like primary obligations of conduct. And obviously the question now arises, what is the standard of due diligence under the Paris Agreement? Generally, on international law, a standard of due diligence is variable. It's dependent on the specific context. And the factors that are important for the Paris Agreement context include the treaty's objectives, treaty's normative expectations, and then differentiation as well. So the treaty objectives, it's pretty clear. It's the 1.5 degree temperature goal under the Paris Agreement, but also includes kind of like the net zero target that we can find in the Paris Agreement, so a balance between sources and sinks. Normative expectations under the agreement include progressive reductions, so reduction commitments have to be progressively more ambitious, mitigation leadership from developed countries, and then also that states have to employ their highest possible ambition in mitigation commitments. Differentiation under the agreement is kind of encapsulated by the CBDRRC principle, so common but differentiated responsibilities, which indicates that both capabilities to address emissions and responsibility for emissions kind of influence states' standard of care. And from all these kind of factors, we see that there's kind of like there's very like high, they highlight kind of very ambitious and urgent objectives, high risks if these objectives are not met, and a strong normative pull towards mitigation as well, all while we're considering the responsibilities and capabilities of each state. And I would kind of say that this, and in the scholarship, people have also said this is kind of like a very high standard of due diligence that the Paris Agreement requires, potentially comparable to the stringent standard of due diligence that the ITLOS has found in its recent advisory opinion, although then some people say that's not a very helpful comparison in some ways, as the ITLOS has actually not specified what stringent means in this context. But yeah, so generally a very high standard of due diligence for the Paris Agreement. But how does this relate to agriculture? So this becomes visible when we also look at subsequent agreement in form of COP decisions, which further influence this due diligence standard. So the most important insight from COP decisions with regard to agriculture is that they reflect states' understanding that the involvement of all sectors is important for the comprehensive mitigation required to reach 1.5 degrees. So this kind of suggests that states are expected to consider all relevant sectors when fulfilling their conduct obligations under the Paris Agreement. So therefore, when parties pursue mitigation measures to achieve their NDCs, states are expected to take into account all sectors, including agriculture, to discharge their standard of due diligence. This is subsequent agreement and therefore only kind of indicates the direction of travel. It's not legally binding, but it's also confirmed by the best available science, as I've kind of mentioned at the start. So the IPCC clarifies that the involvement of all sectors in emission reduction is required to reach 1.5 degrees. So therefore, despite the absence of sectors in this specific treaty text of under the international climate change regime, the due diligence standard still requires the involvement of all sectors in order to get to 1.5 degrees, so the overarching goal of the agreement. This is all obviously still qualified by like common but differentiated responsibilities. It follows that states need to address agriculture emissions in their reduction efforts, depending on their responsibilities and capabilities to mitigate, in order to meet their due diligence standard. So this is the little formula that I've come up with, what I think is kind of relevant to make up this due diligence standard, which requires short-term emission cuts in all sectors and which also includes agriculture. So if we believe that this is the standard of due diligence under the agreement, I just want to go into some kind of what practical relevance could this have? So yeah, so if we assume that this is the due diligence standard under the Paris Agreement, it seems that the current lack of measurable non-voluntary mitigation actions in the agricultural sector might indicate that at least some states are breaching the due diligence standards. So a case could especially be made for rich global north countries with high capacity and responsibility that are not putting in deep short-term mitigation measures in the agricultural sector. So the lack of such like actions in the agricultural sector undermines it could be said to undermine the ambitious mitigation goals that many states proclaim, because, as we said before, science shows that agriculture is necessary to reach so cuts in the agricultural sectors are necessary to reach ambitious mitigation goals in line with the 1.5-degree targets. So especially where states specifically mention the need to reduce agricultural emissions in their goals, and as the graph showed, that's about 95% of states that have submitted NDCs, especially where they mention such necessity in reducing them, but then don't put in any specific measures to actually do that, we could argue that there is a breach of their due diligence standard here. It also shows that states are not doing their utmost to address climate harms. They're kind of consistently brushing over robust and short-term mitigation measures in the agricultural sector. All of this might indicate that at least developed states with high responsibilities for emission and capacity to reduce them fail to discharge the due diligence standard by employing inefficient reduction efforts in the agricultural sector. But even if we don't think that this is the standard of due diligence, or if we don't think that it's breached in some ways, I think that this analysis still shows that the international climate change regime's mitigation logic kind of clearly envisions further and more robust action for agriculture under the regime than what developed states are currently employing, mostly just because such deep emission reductions in the sector are necessary to reach the overarching goal of 1.5 degrees under the agreement. Lastly, I want to quickly go into some broader implications of this research. So on the one hand, it kind of, with regard to agriculture, this kind of analysis demonstrates that the sector is insufficiently regulated and addressed under the climate change regime. It reveals that there seems to be some specific reluctance to reduce agriculture emissions, which leads to the breach of even very limited due diligence obligations under the regime. And this is kind of something that should be addressed in the future in order to achieve the goals of the climate change regime and the Paris Agreement. It also brings us a step closer to defining what states are obligated to do under the Paris Agreement, and shows us how sectors fit within the mitigation logic of the Paris Agreement. So under domestic laws and domestic mitigation efforts are often structured in a sectoral way. They're structured across different ministries, and therefore it's quite interesting to see how does this national structure fit within the international climate change regime and international obligations that we have in regards to climate change as well. The research also kind of raises some questions about the fair distribution of emission reduction and responsibilities in the agriculture sector, just given the intrinsic link between food security and livelihoods in the agricultural sector. It raises some question of, can the climate change regime actually adequately distribute reduction burdens in the sector? And then finally also raises some questions about states' responsibility, kind of a need for further analysis under the law of state responsibility. Can a breach of due diligence, as assessed in this paper, constitute international martial act? What are the potential consequences? And what is the practical relevance of this? So this is all that I have for today. Thank you very much for your